Welcome to Module 5, Chapter 4, Case Studies and Real-Life Applications in DPDP Act. In this chapter, we will explore the real-world implications of the Digital Personal Data Protection Act, DPDP Act, 2023, through detailed case studies. These case studies highlight the importance of compliance with the Act, the challenges organizations face regarding data protection, and the impact of data breaches. By examining these real-life scenarios, we aim to reinforce key principles of the DPDP Act and provide actionable insights for businesses to ensure compliance. Data breach in a healthcare institution. In this case study, we explore the breach of sensitive personal data at HealthCarePlus, a prominent healthcare institution. The breach compromised the personal data of over 500,000 patients, including health records, medical history, contact details, and payment information. The breach occurred due to unauthorized access to the hospital's database, which was not adequately secured. Violation of the DPDP Act. Under the DPDP Act, Section 8, data fiduciaries are required to implement appropriate security safeguards to protect sensitive personal data. However, HealthCarePlus failed to update their security measures, resulting in a significant breach. The data was not adequately encrypted, making it vulnerable to unauthorized access. Incident response. Upon discovering the breach, HealthCarePlus failed to notify the Data Protection Board and the affected individuals within the required timeframe of 72 hours as mandated by Section 8 of 6. Due to internal communication issues, the notification was delayed by 12 days, violating the DPDP Act's breach notification requirements. Consequences and penalties. The Data Protection Board investigated the delay and issued penalties. Delay in breach notification. A fine of INR 100 million was imposed for the failure to notify the breach within the stipulated time. Inadequate security measures. An additional fine of INR 150 million was imposed for not securing sensitive personal data in compliance with Section 8 of 5 of the Act. Lessons learned. Timely breach notification. This case highlights the critical importance of notifying both the regulatory body and affected individuals promptly in the event of a data breach. Delays in breach notification can lead to significant penalties and loss of trust. Enhanced security measures. Institutions, especially those in sectors like healthcare, must implement strong cybersecurity frameworks and ensure that sensitive data is properly encrypted and protected from unauthorized access. Compliance with data protection policies. HealthCarePlus should have established robust internal protocols, including regular security audits, to detect vulnerabilities and prevent breaches. Case Study 2. Data transfer to a foreign jurisdiction. HealthCarePlus, a fintech company based in India, transfers personal financial data of its Indian customers to a data processing facility in Germany. The company entered into a contract with the EU-based service provider, FinData GmbH, and began sending sensitive data like account numbers, transaction histories, and customer identification documents for fraud detection purposes. Violation of the DPDP Act. While the data transfer was legitimate for fraud detection, the DPDP Act, Section 16 imposes restrictions on cross-border data transfers. The company failed to ensure that Germany met the data protection standards required by the DPDP Act. Furthermore, there was no proper data transfer agreement, DTA, in place outlining the safeguards for protecting the data during its transfer. Non-compliance issues. Lack of due diligence. HealthCarePlus did not conduct the necessary due diligence to confirm that its foreign partner, FinData GmbH, complied with data protection standards equivalent to those required by the DPDP Act. No data transfer agreement. The company failed to create a data transfer agreement, DTA, which should have set out the specific terms for handling, processing, and safeguarding the sensitive data. Consequences and penalties. The Data Protection Board imposed a monetary penalty of INR 50 million for failing to comply with Section 16 regarding cross-border data transfers and for not ensuring appropriate data protection safeguards. Lessons learned. Data transfer safeguards. Before transferring data across borders, businesses must ensure that the recipient country has adequate data protection laws or use mechanisms like standard contractual clauses, SCCs, to safeguard the data. Due diligence. Data fiduciaries should conduct thorough checks and risk assessments before entering into data transfer agreements with foreign entities. Data transfer agreements. A legally compliant data transfer agreement is essential to protect both the business and its customers during international data transfers. Case Study 3. Implementing data protection policies in a tech firm. TechNO Limited, a tech firm specializing in cloud-based solutions, processes personal data from several sectors, including e-commerce, education, and healthcare. To align with the DPDP Act, TechNO Limited decided to implement robust data protection policies across its operations to avoid legal repercussions and ensure compliance. Challenges faced. TechNO Limited faced several challenges when trying to implement data protection policies. Complex data processing activities. The company processes a wide variety of personal data across multiple sectors, which makes compliance with the DPDP Act more complicated. Lack of internal framework. Initially, the firm did not have a comprehensive data protection framework in place, and its policies regarding data retention, access control, and breach response were unclear. Employee awareness. Many employees were unaware of the DPDP Act or its implications for their work, creating a knowledge gap regarding data protection responsibilities. Steps taken for compliance. Appointment of a Data Protection Officer, DPO. As per Section 10 of the DPDP Act, TechNO Limited appointed a qualified DPO to oversee compliance efforts and coordinate with different departments. Development of privacy policies. The company developed comprehensive data privacy policies outlining the process for collecting, using, storing, and transferring personal data. These policies included clear procedures for obtaining consent and addressing data access and rectification requests. Conducting data protection impact assessments. To ensure data privacy risks were identified and mitigated, TechNO Limited implemented DPIAs as part of its compliance strategy. Employee training. The company invested in employee training programs to ensure that all staff involved in handling personal data understood their responsibilities and how to comply with the DPDP Act. Results and compliance achievement. Operational efficiency. After implementing these measures, TechNO Limited significantly improved its internal data processing practices and enhanced the security of user data. Regulatory compliance. By aligning its operations with the DPDP Act, the company avoided potential fines and penalties. Additionally, the company's leadership gained a competitive advantage by demonstrating a commitment to data protection. Comprehensive data protection policies. It is essential for tech firms to create detailed policies covering all aspects of data processing, including data collection, storage, transfer, and destruction. Employee education. Ongoing training and education on data protection laws ensure that employees are equipped to handle data securely and comply with the DPDP Act. Regular risk assessments. Data protection impact assessments and regular audits help businesses identify risks and adapt their operations to changing data protection regulations. Conclusion. These case studies illustrate the challenges businesses face under the DPDP Act and the importance of adhering to its provisions. Whether dealing with data breaches, cross-border data transfers, or implementing data protection policies, organizations must be proactive in safeguarding personal data. The lessons from these cases underline the need for strong internal protocols, robust security measures, and thorough compliance practices to mitigate the risk of penalties and protect the privacy of individuals. By adopting these best practices, businesses can ensure regulatory compliance and maintain the trust of their customers and partners. Thank you for reviewing these case studies. Stay tuned for the next chapter, where we will explore practical steps to achieve compliance that apply to its processing under the DPDP Act. Thank you for joining this session. In the next lesson, we will explore the practical steps to achieve compliance, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.